Okay, so I hope everyone can hear us well. Welcome to the webinar. We're going to get going now, and I think we'll expect a couple of more people to join as we go along. Now, in this webinar today, which is kindly supported by the law firm Freshfields, you'll hear three perspectives on Ban the Box. You'll hear from myself, the campaign manager here at Business in the Community, with an introduction to the campaign and also a bit of my own perspective on Ban the Box. We've then got George from Trafford Housing Trust joining us to provide the employer's perspective. And finally, we'll be hearing from Robbie, who's in employment with the Ban the Box company, and will provide the job seeker's perspective. And hopefully this will give you a picture of the importance of the campaign, but also what you can do to give people a fair opportunity to get into work. So before we get onto the detail, what is Ban the Box? It's a campaign that we launched back in October 2013 in an effort to change the unnecessary exclusion of skilled people who happen to have criminal records. What we're looking to do through the campaign is create a fair opportunity for people with criminal convictions to compete for jobs based on their skills and experience. And to do that, we're asking UK businesses to remove the tick box from application forms that ask about unspent criminal convictions if they have it on there. To develop an alternative process to take criminal convictions into account through the recruitment practice that they have, and finally to let applicants know that that's what they're doing, so to publicly commit to considering skills and experience first before asking about criminal convictions. So we've been working in this area for some time. We've been doing quite a lot of work with employers who are keen to work with ex-offenders. So why did we choose Ban the Box as our campaign? Now, what you can see on the screen is that employment is really, really crucial to give people a chance to get into to work, to improve their lives, and to move on from their past, with employment reducing reoffending by up to 50%. But actually there was a gap between this really important role that employers can play in changing people's lives and the reality of how they were responding to criminal records. In fact, surveys showed that a really high proportion of employers were using criminal records to make decisions about candidates, to reject them or to select other candidates over and above those with criminal records. And 1 in 7 were rejecting applicants outright, whatever their offence. And there was actually a campaign running in America, a Ban the Box campaign over there, and we learned the really important impact that simple changes to recruitment practices can have. In Minneapolis, where they banned the box on all state job roles in 2007, after that 57% of applicants with convictions were hired, as opposed to 5.7 in the period before they banned the box. So what we did here was create a campaign which would enable companies to talk about and review their policy and practice to create a more considered approach to criminal records. Now, before we get into some of the detail about the stages you go through to consider criminal convictions, we'd like to test your knowledge a little bit first and just see what you know about criminal records. So you'll see a question up on your screen. So in court, what percentage of convictions result in an immediate custodial sentence? Is that less than 10%, 10 to 30%, 31 to 50%, or over 50%? If you click on the boxes on your screen, you'll be able to give us your answer, and we'll just give you a few seconds to respond to that. Okay, so we've got some interesting results, and I have to say that the majority of you were wrong. So 29% of you said that less than 10% would result in immediate custodial sentences. 57%, the majority, said between 10 and 30%, whilst we had some smaller numbers for 31 to 50% and over 50%. In fact, only 7.4% of sentences by the court are for prison, are for immediate custody. And this is based on sentencing in the UK courts in the previous year up until March in 2015. And what's really important to be aware of is whilst there is a cohort that will go to prison and will potentially have a gap on their CV, actually 71% of court sentences are fines. So there's a really wide range of sentences being handed out. And with those sentencing stats in mind, it's really clear that a tick box approach won't work. It doesn't give the opportunity to contextualise and to explain, and you are dealing with lots of people who are from different backgrounds and have a wide variety of criminal convictions. And you need a recruitment process that approaches that in the right way and reflects the complexity of this. Not only that, people have told us time and time again that they're really put off by that tick box. They believe they won't be in with a chance if they see it on a form. So we believe the box is not the right way to go about it. Employers are missing out on skilled people who are either being excluded by the employer or are excluding themselves from the running. And a case-by-case approach is much more likely to work well for everyone. So far, in the couple of years that we've been running the campaign, 49 employers have signed up to show that they're committed to offering fair opportunities to people with criminal convictions. As you'll see on your screen, they're from lots of different sectors, businesses of a huge range of sizes. So it really does show that it's possible for everyone to do that. So if you're interested in following their lead, adding yourself to that list and that slide that we had before, then we've identified 4 different stages that companies often go through in their process of signing up. And I'll run you through briefly some key points that's worth being aware of at each of these stages. But firstly, as you'll see on the screen, the important thing to know is where you're starting from. As we've talked to employers throughout this campaign, we've really heard from them that actually often you don't know what your practice is at the moment. It's not something that you've really considered, and that was reflected in the registration report. When we asked you to sign up, we asked whether you knew whether you had a tick box on your application form, and 20% of you said you didn't know, and we had a relatively mixed bag of whether you thought you did or you didn't, but actually a couple of people from the same company had different responses. So what's important is to find out what you're starting from and what you need to change. Following that, there may be various legal or contractual requirements that you need to take into account that are dependent on your business. From that information, you can look at developing an alternative recruitment process or just improving the one you've got if you actually don't have a tick box now. And then finally, there's various things that you can do to make sure that Ban the Box is really effective within your business and put it into practice. So before I give you a little bit of background on some of the legal terminology that might be useful for you, here's another poll. So we'll just open up a question for you to answer, and the question is, applicants with a criminal record are legally required to disclose all convictions when asked. Is that true or false? And as before, we'll just give you a bit of time to answer that question. So 42% of you said that was true, and 58% said it was false. Now, the relatively even response is probably due to the fact that it was a slightly trick question. So first of all, can applicants with a criminal record are legally required to disclose certain convictions when they're asked? This is in accordance with something called the Rehabilitation of Offenders Act, which is a legislation that defines the length of time that the candidates are required to disclose their convictions dependent on the sentence that they were given. For most roles, so your typical role that you might be recruiting within your business, that's called an unregulated role, and that's subject to the Rehabilitation of Offenders Act. For those, candidates only need to disclose convictions before they've completed that time defined by the Act, and those convictions are called unspent. For other specific roles, which might be a teacher, a doctor, the ones that are regulated and exempt from the Rehabilitation of Offenders Act, they'll be required to disclose more. They'll need to disclose convictions even if those time periods have passed. So it's important for you to know which type of role you're conducting, which type of role you're recruiting for, and ask questions accordingly. So what you'll need to do once you've decided, we'll come back in a second to the to some of those legal terms and some of the criminal record checks. I know that when a few of you signed up, you asked questions about this. But if you're deciding not to ask at the first stage, you're developing an alternative recruitment process, then you need to consider when and how you ask. If you don't ask at the first point, there are various options that you can pick from about when you will ask. And we know there's not a one-size-fits-all model for all companies. The principle of it is, if the later you leave it, the more likely you are to consider skills first. But it may be that there's a best fit for your business and a best way in which you feel it fits within your recruitment process. You could ask after application, but before interview, and that's often done by candidates submitting a form to HR. You could ask after interview, or you could ask once you've offered a job and made that job conditional on disclosure, or you could make a decision not to ask. In each of those cases, the best practice is to use both written disclosure and ask questions. So you can get people to set out the context of their convictions and give you that wider information in a written statement. But then you are able to ask further information, delve into the details you might need to make an informed decision. Some of that information can then be verified by a criminal records check, but we'd always advise not to just go with a criminal records check because that doesn't give you the context you need. When you're putting your process into practice, you'll also need to make sure that people know about it. So you'll need to make sure that recruiters understand how their role is part of your business's commitment to ban the box, and they're equipped to respond if they have a candidate who comes to them and has a criminal record. They'll also need policies and processes to help with the reality of decision making, because what you'll find is not any applicant, it will be the same, and they'll need to understand how to deal with the differences in the context that comes with the disclosure of a criminal record. And it's also really important to make sure that applicants understand the process. They know what they're being asked for, when, they're given a chance to prepare, and particularly if they're employed by you, they understand what's going to happen to that information. It is very sensitive. They may have disclosed it multiple times before they've got into a job, and they'll want to know who else knows. Best practice really is that only those that really need to know are the ones that are told. That might be their manager, for example, but keeping it to a minimum allows people to really move on from their past. Now, just to go back to the questions that often come up about criminal records checks, you'll see a slide on your screen now, and we will send this around to you as well, so you've got the information to hand. But as I was mentioning before, there is various types of regulation and acts that define what you can find out. For most roles, those unregulated roles where you only find out about unspent convictions, you can conduct a check, but this is called a basic disclosure, and it's done by Disclosure Scotland, but for the whole of the UK. And that just gives you the information you're allowed to know. And it's not legally required for you to do that, but you can if you want to. For those other roles, the regulated roles that we mentioned before, there are two types of checks, and depending on the exact functions of the role, you'll either be getting a standard DBS check or an enhanced DBS check, and this is the new form of a CRB, which you may well have heard of more. So just to finish up my section, I just wanted to run you through, I guess, a little bit of perspective on how I spend my time when working on Ban the Box and what I can do to help you. My role really is to help you achieve this. We want to encourage you, of course, but I can also offer support at all the different stages that you might be going through as you look into this. I can answer questions. I can also provide various different examples. We've now got 49 employers who have officially signed up, and many more that we're in active conversations with. So there may well be one within your sector that we can point you to and help you to understand how they've done it. We also have various guides and resources that we develop to help you to do this, and I know that we've only had a chance for a whistle-stop tour of the kind of how and when you ask questions, but these are covered in much more depth in the guides that we're producing at the moment, a How to Ban the Box guide, which will be coming out in the middle of October. So get in touch. My details will be at the end of this presentation, and we're really happy to support you to do this.